When you see men fall, don't laugh. Learn. Learn. Because you're on your way up. And the things that tempt people to fall, you and I are not free from that temptation, nor from the weakness that will cause us to stumble and fall. When you laugh at somebody else's fall, white or black, rich or poor, your enemy or your friend, you are laughing and opening a way for your own demise when you do that. Because to laugh and not learn, to make mockery and not to understand, is to make the same mistake yourself.
All right, so on the latest news, we're back for another episode from the Porter Perspective Podcast with your host, Elijah Porter. This is a podcast specifically for men that focuses on teachable moments, correctable actions, and life lessons for men. Now, when we have this discussion, and of course, his face has been plastered as the poster child for alleged heinous acts involving sex trafficking, drug trafficking, and so many other heinous activities, criminal acts. When we have these conversations, what must be at the forefront is understanding that we as men must learn that before we condemn, before we poke fun at, we should understand that these are real people. And these circumstances and these situations where we believe that we will never be in, you never know. So when we have this conversation and you learn from this, I want you to be able to walk away with some fundamental understanding on how to approach, navigate, and control your environment based on the decisions that you make. Because everything that's happening to Mr. Combs, along with anyone else that is potentially implicated or will be at some point, comes down to decisions. The decisions that we make define us. And I remember when I was younger, my father would often impart wisdom onto me and say, the difference between you and anybody else is a choice. Unfortunately, there are certain circumstances in which you may be forced, or you feel as if you're forced to lean toward one way over the other. But as we know from the book of Job, that these things are all part of the test of your character, the test of your will, the test of your spirit. So we started with Minister Farrakhan because the context of this, where we're going to be unpacking the legal, where we're going to be unpacking the cultural, where we're going to be unpacking this from an educational lens, it starts with the scope. And the scope of this is education, enlightenment, and empowerment through the circumstances that have come about from others. In this case, the prime example is going to be Mr. Combs. All right. And so what's happening now, and if you don't know, there has been several cases, most notably the Cassie case, in which it was supposedly settled within 24 hours of a lawsuit being filed. And that has opened up a floodgate of other cases against Mr. Combs and so many other celebrities. And so now the question then becomes, how can you arm yourself? How can you protect yourself in these circumstances? How can you avoid being in these circumstances potentially? And now that these lawsuits are going back and forth, what can you do to best position yourself strategically for a favorable outcome? All right. So we started here. And so now what I want to do, I want to focus our attention to the docket. And this is the exciting part. I'm super excited about this. Let me see if I could share my screen here. Let's go here. Okay. Let's start here. Okay. All right. So now we're going to jump right into the education. Okay. And again, as you all know, I'm not your attorney, but I am a duly licensed attorney in both the state of California and the state of Georgia. And what we're unpacking and what you're seeing here is a Jones versus Combs. And whenever you see the et al, the ETAL, it means that there are other people involved. So we see the New York Southern District Court that lets you know the court that this case is being filed in. You see the name of the judge, you see the case number. You also see the nature of the suit. Racketeer, influenced, and corrupt organizations. Now, pause. Let's not just gloss over that. What do we know about racketeering? What do we know about corrupt organizations? And for anyone that doesn't know, I'm from Atlanta. And you see, we say Atlanta. We all know what's going on right now in the case of Young Thug. And so the concept of racketeering, the concept of corrupt organizations, it starts to give you a lens into the fact that what underlies this is a form of criminality, that this is bigger than just one individual. So immediately, even though you see Combs, you know that other people have to be implicated and or involved, allegedly, according to this so-called complaint in this suit, because it is referring to racketeer, influenced, and corrupt organizations in terms of that statute. So we should already be expecting entities. Now let's take it a step further. The fact that this is a civil case and not a criminal case tells you a couple of things. Number one, it lets you know what the desired aim is. And you're going to see this. And this was in the initial complaint, but you'll see this throughout. Typically, when a person is pursuing civil action, civil is related to what? Money. So anytime you see civil, you're thinking about money. Anytime you see criminal, you're thinking about a person serving a certain amount of time behind bars. And the reason why this matters is because the burden of proof is different. That is critical. The burden of proof is different. When you're thinking about criminal, beyond a reasonable doubt, that's a higher threshold. When you're thinking about civil, it is a lesser burden that has to be proven in order for you to satisfy. And so when the focus has a lesser threshold that needs to be proven, and when the focus is not about necessarily prison time, but about compensation, damages of some kind, that allows you to lean into why sometimes attorneys will take on these cases in a form of contingency, because the insurance from said companies that are supposedly a part of this corrupt organizations, perhaps, will be the ones to pay for. So that is the lens. That's the context. Okay. Now, let's take a look. So we understand the difference between plaintiff and defendant, right? The plaintiff, the person that is bringing the action. The defendant is the person who the action has been brought against. So we see a list of names. We see Justin Dior Combs. We see Sean Combs. We see Combs Global Enterprises. Sounds like a business. We see Cuba Gooding Jr. We see Lucian Charles Grange. And now in this situation, what do we notice? We notice that he is represented by counsel. This is very important. So you have Combs. You have Lucian Grange, Christina Coron, Love Records. You have Motown Records. And you notice these parties are represented one and the same by the same individuals. You have Universal Music Group, and you notice these parties are represented one and the same. And then, of course, here you have the plaintiff. And the plaintiff is Mr. Rodney Jones, who is being represented by his attorney, Tyrone Blackburn. And we're gonna unpack him as well, because there's a lot to discuss in that situation in terms of who he is, his background. Does he have a history of filing these type of complaints? If he does, has he ever been sanctioned before? Will he be sanctioned now? Yeah, definitely a lot of interesting questions. But the initial thought process is that, number one, we understand that from an educational lens, we're learning. Number two, we understand who the plaintiff is. The plaintiff is Rodney Jones. Rodney Jones is represented by Tyrone Anthony Blackburn, right? And then we also understand that the Universal Music Group, Motown Records, and Lucian Grange are all represented by the same firm, Pryor Cashman LLP. So now that we understand that and we have that frame of reference, we can move on to the next part of this. But it shouldn't go without mentioning that as of right now, the defendants of Combs and Combs Global Enterprise and Cuba Gooding Jr. and Love Records and others has not necessarily been disputed just yet. All right. So let's move to the next part of this, right? Like now that we see this action, we know that a lawsuit has been filed. Everybody's been talking about the lawsuit at this point. I mean, you've seen Stevie J be mentioned, you've seen Sean Diddy Combs be mentioned, you've seen Young Miami, you've seen so many different people who have allegedly committed some heinous acts, or been part of, or witnessed, or participated in, sexually harassed, or moved drugs, or all of these different things. So now we need to really unpack, how did these attorneys respond to that initial complaint? Okay, so that's the next part. Let's move to phase number 2. Let's share the screen here. Let's start with this. I think this is a good. Okay. All right. Let me know if you all can see this in the chat. So what we have right here, and I had to pull it because I think sometimes people can go with the blogs and you can go with the articles, but it's best to just pull it from the source. If you have access to it, let's just pull it from the source and let's discern it. Let's dissect it to the best of our ability. So what we have right here is Rodney Jones, right? Who you're probably familiar in some capacity, Little Rod. And we have a memorandum of law in support of a motion to dismiss the first amended complaint. Now, you might be asking, what is a motion to dismiss? Well, essentially, what the attorneys for the defendants are requesting, they are requesting that for some reason, on some basis, that this case should be dismissed. And so now they put together a memorandum of law to support that. And so here you start out with your initial table of contents, your cases for your authorities. And you see that there's a lot of time and effort that's going into preparing these type of pleadings. All right. So I want you all to follow this. We're gonna break this down, make sure that it's not too much legalese, but just getting a good broad stroke understanding on what exactly has happened now that attorneys have responded to this first amended complaint. Okay, so here we go. You have defendants Sir Lucian Grange, Motown Records, and UMG Recordings incorrectly identified in the first amended complaint as Universal Music Group, which is not a juridical entity. Let me tell you what he just said. Number one, this attorney is sloppy. He doesn't even know the exact entity in which he should be referring to us as. He incorrectly identified us. And so what the attorney is conveying, what the firm is conveying to the court, is that this isn't someone that you can take seriously from the very beginning because we were incorrectly identified. So shots are being thrown, right? This is one of those jabs. And then you take it a step further to submit this memorandum of law in support of their motion pursuant to, and then they have the rules to dismiss. And then there's a preliminary statement. And notice that there are footnotes that are a part of this. Notice that there are citations, right? Plaintiff and his counsel have made criminal accusations against Sean Combs and his associates, whatever the truth or falsity of those accusations, without the slightest factual or legal basis and in reckless disregard for Rule 11. Now that begs the question, right? What is Rule 11? And we're going to unpack that. They have also improperly accused Grange. So now we're going back to that term improperly being used. So number one, you referred to us wrong. Number two, you're improperly accusing people in this alleged lawsuit, and for that basis alone, you need to dismiss this, judge. This is getting out of hand. This is what is being conveyed, right? So they have also improperly accused Grange, UMG Recordings, and Motown, collectively the UMG defendants, of assisting, participating in, or helping to conceal the alleged conduct of Combs and his associates. So two things can be true, right? They are distancing themselves from Mr. Combs while at the same time denying any involvement in this case. This is very important for us to understand the role of legal and how legal is a form of military science. When you're looking at jurisprudence and you're looking at the judicial system, you must understand that this is military science at play. And what underlies military science are a series of tactics in which one is looking to navigate in a secure fashion a way to protect themselves in a form of self-preservation, while at the same time employing tactics of concealment, employing tactics of distancing, employing tactics of isolation to ensure that the character and the nature of said parties looks a certain way. And so what is happening here is they're making it very clear, we're not a part of this. And the fact that you would even include us in this is such an egregious claim. We've never even heard such things, right? So let's take this a step further. So now you got to get into the fact, how can they prove that? And that's when you get into declarations and affidavits and other things of that nature. But we'll get to that, okay? All right. But not only do both the FAC and unauthorized SAC as to the UMG defendants violate rules 8 and 12F, the theories underlying the FAC and SAC for the same claims are completely different and irreconcilable. Man, I mean, listen, they are just saying that this attorney is incompetent, that his theories are completely made up, and he's going to respond. You will see his response. So as set forth in the Zacharian declaration, while the FAC alleges Motown Records was the parent company of Love Records, that Grange allegedly knew of alleged Combs sex trafficking because he supposedly saw it ongoing at Combs' homes, and the UMG defendants allegedly delivered bags of cash to Combs, the unauthorized SAC jettisons every one of these allegations. Sheesh. Instead, now Love Records and Motown UMG Recordings are supposedly in a general partnership. What is he saying? He's saying that you have no idea what you are talking about. He's all over the place. He's jumping from here to here to here to here to there. He has no consistency. There's no veracity that can come out of these claims, Judge. Now, look, to be fair, right? There are many situations in which a client will not disclose or reveal or share all information with you to ensure that you can put forth an accurate complaint. I mean, because a lot of times if you're taking these cases on contingency, you have the word of said client and whatever proof that they have. And of course, you should be doing your due diligence and asking questions, but things can happen where a client can claim something or have supposed proof of something, and it could be misinterpreted. It could have not aided you in presenting whatever your case is. And so what's important in this situation is to understand that they are essentially saying you have no idea what you're talking about. The fact that you're suggesting that this was a parent company, but then you turn around and say it's a general partnership. Did you not do your due diligence to figure that out prior to? Like, what is happening here? Then you're talking about delivering bags of cash. Who carries around cash? Shout out to Attorney Willis, because again, right, there are attorneys, there are people who keep large amounts of cash. So let's keep moving forward with that, right? Then you have that Grange allegedly knew of Mr. Combs' sex trafficking because he supposedly saw it at his home. You know, did these allegations in this complaint aid or prompt what led to the raiding of Mr. Combs' homes in both, I believe it was LA or Miami? We'll see, right? All right, let's keep going. So it goes on to say Grange was never at Combs' home and no cash was ever delivered. Instead, the UMG defendant supposedly should have known that the payments made to Love Records under the license agreement were allegedly misused by Combs for his sex trafficking activity. Wow. These newly minted allegations were entirely invented by Mr. Blackburn, and they are as false as the theories of the FAC. Hey man, I got where's my drink? This is, I need some coffee. I mean, this is crazy right here. Let's keep going, right? The court can readily determine just from the argument section below that the FAC should be dismissed pursuant to Rule 12b-6 because the plaintiff has not stated and cannot state a claim against the UMG defendants. And see, this is where the legal and the technical, there's a class in law school known as civil procedure. And civil procedure is about the formalities of litigating a dispute. And so there's a process. There are rules. And if you are not familiar with the rules, the technicalities can lead to being practical reasons for cases to be dismissed. One of the first things that we learn, and we'll likely see that in a little while, is failure to state a claim for relief to be granted. Right? This idea that you put forth this complaint, you have wasted dollars of your time, the court's time, our time, and judge. This is just outrageous. So this is the angle that the defendants, the UMG defendants law firm is taking. And this is standard. In all honesty, this is just a part of war. And so what I want everybody to understand for the Black men that are listening, that this is warfare. And you can easily be involved in this lawsuit. So even though this is related to Mr. Combs, this is a quote unquote salacious topic in a sense. This is trending at the moment, at any moment in time. I mean, easily, the average person is sued or involved in a lawsuit at least 5 times at some point throughout their life. At least it was that way, a few years ago, where you think about it, you have divorce. Right? People get married, you got divorced, you got a business deal that may go south. You may owe someone some money. You may get behind on your mortgage. You may end up in foreclosure, or you may get behind on your rent. You may end up in eviction, or it may be a circumstance where a business partnership didn't go well. You may end up in a dispute over that. So there's so many instances in which you can get involved into legal. So I want you to understand that when we're looking at this, yes, we're talking about Mr. Combs, we're talking about the UMG defendants, but I want you to understand that it is very plausible. It is very likely that at some point you will be involved in a dispute. And I want you to understand that the defendants in this particular case are just simply doing their job. So don't take this as, an unnecessary shot at anything of that nature. So let's keep going. All right. Let's move around a little bit because, I think that kind of, it's the same thing, right? The foundation of the claims against the UMG defendants, here we are, right? In the FAC is a throwaway line in paragraph 9 alleging Motown is the parent company of Love Records. Based on this assertion, the FAC alleges that the UMG defendants had a duty to supervise and control Combs and failed to perform that duty. Motown was never Love Records' parent company. Their sole relationship was pursuant to a license agreement entered into May 2022, granting Motown the right to distribute a single Love Records album featuring Combs' performance. The license agreement was terminated as of February 1st, 2023. You don't know your facts, counsel. Sheesh. This license agreement is a commonplace commercial contract. It is not a general partnership. Motown is not Love Records' parent company. Every claim based on the alleged failure to perform non-existent supervisory control over Combs is baseless. So in the initial complaint, and then you can see this from the setup, right? What they're saying is that for you to suggest that Motown, that UMG, that Lucius Grange, we're supposed to have supervisory authority, respondeat superior, right? was supposed to have supervisory authority over the actions of this alleged sex trafficking that Mr. Sean Diddy Combs was engaged in is completely baseless. It's completely false because that relationship, because you have to prove that that relationship existed where that duty would be needed to be adhered by the UMG defendants in this case. And so what the attorney is doing, he's dissecting through that argument, and he's essentially stating that such an argument doesn't have an actual basis simply because that relationship never existed. And this is a licensing agreement, and a licensing agreement requires different duties and obligations than a parent subsidiary or a general partnership dynamic. Are you following me? So the first line of attack is to attack the very rationale that you proposed and to cripple it and to weaken it to where to the judge, this should be easy for you to resolve. Here we go. Linked to the false parent company allegation, the FAC alleges that Grange and Ethiopia, who has been dismissed from this case, supposedly attended listening parties at Combs' houses in Los Angeles, Miami, and New York, at which underage girls and sex workers were plied with drugs and alcohol, and at which plaintiff claims he was sexually abused. Again, based on a non-existent respondent superior relationship, we just talked about that, the FAC falsely claims that Grange, and when we say FAC, First Amendment complaint, falsely claims that Grange and Ethiopia should have but did not stop Combs' alleged misconduct. But Grange has never been in any of Combs' homes. And Ethiopia was in his Los Angeles home only 4 times. She was never in his Miami or New York homes, all of which were for business, before plaintiff started working with Combs in September 2022. So plaintiff never saw Grange or any of Combs' homes. Grange and Ethiopia had no knowledge nor any way of knowing of any such alleged activity, and no duty to control Combs, having been put on notice of the falsity of these assertions. All of these allegations are jettisoned in the unauthorized SAC. Man, what are we saying right here, right? What just happened? What did these attorneys literally just say? So what they're saying is that, number one, you see how they reintroduce and they're echoing the theme that everything that this plaintiff is suggesting, that this plaintiff and his counsel is suggesting, is based on a falsity. It is based on a foundation that cannot hold itself. And to take it a step further, to prove to you that it's based on a falsity, number one, he doesn't even understand the nature of the relationship in the business, because you're presuming that this is parent subsidiary. You're presuming that when you found out that it wasn't parent subsidiary, then you changed it to a general partnership. And then only to find out that it was actually a licensing agreement that was in place, which is just very commonplace. So this isn't anything unorthodox. Then to take it a step further, then you allege that Mr. Grange and Ethiopia were a part of going to these listening parties and participating in seeing this alleged sexual abuse and these underage girls and sex workers who had drugs and alcohol. And for you to say that, only for there to be declarations, for there to be affidavits, for there to be claims contrary to that I have never even been in your house. That the time that I did go to your house, I didn't go to all those houses that you said that I did. I actually went here and I went there, and I was only there for business. And that is proven by the time of day, or that's proven by the email correspondence and the communication. But there's never been any other instance for me to be there. So now what they're doing is they're unraveling or attempting to unravel the plaintiff's argument based on there being misrepresentations and mistruths, and the idea that this is a person, a party that cannot be trusted. Sheesh. Let's keep going. Okay. Let's move around, because I want you all to follow this, and I don't want to get bogged down into the legalese, but this is so much. It's really so much to unpack here, right? Because let's start right here. So the FAC also alleges that the UMG defendant supposedly supplied Combs with cash he allegedly used for his sex trafficking activity, Another false allegation, jettison. I've never seen jettison used so many times. Like I've never seen jettison used so many times. That is this like that's one of their favorite words. Shout out to jettison, right? In the unauthorized SAC, and it asserts that the UMG defendant supposedly should have known about Combs' alleged sex trafficking activity because of the claims asserted by Cassie Ventura. These assertions are not only false and legally baseless, they are chronologically false. So not only are you making legal arguments that make no sense, even the order in which you're presenting the arguments, it can't even be in any way, shape, or form true. You're just a liar. You are a liar. And this is nothing but a payday for you. That is what counsel is saying. All right, let's keep going. And look at this. This FAC is based on naked conclusions. Not a single fact is pleaded showing that any cash was ever provided to Combs or Love Records. Motown paid or reimbursed Love Records for its invoiced recording costs pursuant to the license agreement as part of an advance against Love Records' share of album revenues. It did not provide cash. Wow, and I'm looking at this footnote right here too, right? The First Amendment complaint also accuses the UMG defendants of failing to file tax documents reflecting these non-existent cash payments. But plaintiff and his counsel could not possibly know whether tax documents were filed. So either the tax filing assertion is made without the slightest knowledge, or knowing that their cash allegations are false, plaintiff and his counsel also know that no tax documents were filed because none were required. So, hey man, it's scary hours out here. It is scary hours. So look, so it goes on to say plaintiff and his counsel lack any good faith basis for asserting the Racketeer, Influenced, and Corrupt Organizations Act and Trafficking Victims Protection Act. As will be shown below, the RICO claims are wholly conclusory and fail for numerous reasons, including lack of particularity, lack of any viably pleaded predicate acts, lack of a viably pleaded enterprise, lack of alleged direction and operation of the management of any assumed enterprise by the UMG defendants, and lack of causation. Sheesh, we cutting through. Listen, man, plaintiffs' TVPA claims against the UMG defendants are spiritless, lacking a single pleaded fact. They fall for numerous reasons, including there's no private cause of action for aiding and abetting violations of TVPA. There are no allegations from which anyone could plausibly infer that the UMG defendants knew or could have known of and facilitated the alleged sexual misconduct of others described in the First Amendment complaint. And there are no facts pleaded showing that the UMG defendants financially benefited because of the alleged sexual misconduct described in the FAC. And now jettison cash allegations are completely false. Man, listen, man. I mean, at this point, and we haven't even, it seems like it just gets worse from here. It seems like it just gets worse from here, but the basis of it, you haven't proved anything in your complaint. You haven't provided any facts. And so you come here, let's unpack this, and then we're going to go and we're going to see how the plaintiff responded. All right. So I want you all to take away like just the legal aspect of it, right? Because again, this is what your defense counsel should be doing. Like they should be responding in this manner. Of course, representing you zealously. So to survive Rule 12b-6 dismissal, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Then they go on to say, threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice, nor do legal conclusions masquerading as factual conclusions. Moreover, where well-pleaded facts do not permit the court to infer more than mere possibility of misconduct the complaint has alleged, but it has not shown that the pleader is entitled to relief. So, number one, the plaintiff's RICO claim against the UMG defendants should be dismissed. Courts look with particular scrutiny at civil RICO claims to ensure that the statute is used for the purposes intended by Congress. So now we're talking about the intent, we're talking about the legal basis, and everything, according to the defense counsel, is falling flat on its face. It holds no bearing in this matter and should be immediately dismissed, specifically as it relates to the UMG defendants. And notice that, I mean, at the end of the day, you know, it's nothing personal. This is the nature of business, but Puffy is being held out here to dry. He's being, you know, he's being deserted by his, you know, by his industry friends in this, that they're not even getting involved. They didn't even, you know, attempt to prove or disprove. They just made sure that it was very obvious that they weren't a part of it. So whatever you think you heard or think you saw, definitely, you definitely didn't. So, you know, let's keep going, right? So because the mere assertion of a RICO claim has an almost inevitable stigmatizing effect on those named as defendants, courts should survive to flush out frivolous RICO allegations at an early stage of litigation. This is ridiculous, man. This is ridiculous. This is what counsel is saying. This is absolutely ridiculous. And the fact that you would even bring this up, the stain that this will put on this organization, these companies that I've built for decades, 10, 20, 30, 40, 50 years, and never had any such allegations, allegedly. That is what counsel is leaning toward. And it goes on to say, bald contentions, unsupported characterizations, and legal conclusions, and not well pleaded allegations will not suffice to defeat a motion to dismiss. As discussed below, a civil RICO claim requires that each defendant committed 2 or more predicate acts of racketeering constituting a pattern through an enterprise which each defendant directed the operation and management of, causing property loss for the plaintiff. So they're getting ready to dissect this and break this down element by element, right? So essentially what they're saying is that based on the elements and based on the first amended complaint that you provided, you haven't shown that you can prove what you're alleging. That's the basis of it. So even when you see here, and you know, it goes on to say a RICO claim must charge each named defendant with the commission of 2 or more predicate acts of racketeering activity. You know, here it goes on to say, because plaintiff invokes alleged mail and wire fraud as his predicate acts, he is required to satisfy the heightened pleading requirement of Rule 9b. The courts of this circuit have recognized the policies behind Rule 9b's particularity requirement apply with particular force in RICO actions. So basically it's saying you didn't follow all the rules and that there must be a certain amount of specificity. And it goes on and literally says it right here. Plaintiff must specifically allege the circumstances of the fraud, including the content of the alleged misrepresentations, the date and the place of the misrepresentations, and the identity of the speakers or the writers. The FAC does not remotely satisfy Rule 9b standard of identifying 2 or more particular acts of mail and or wire fraud by any of the UMG defendants. Instead, in a non-specific and patently insufficient group pleading, the plaintiff alleges defendants used the mail and interstate wires to solicit plaintiff Jones and others to utilize their talents and labor to produce music and other tangible goods and services without compensation, as well as the solicitation of sexual encounters with prostitutes, sex workers, and minors and purchase. See, what they're doing right now is they're basically breaking this down to convey to the judge that these things aren't even specific enough, and that there was a heightened standard that was in place based on the allegation in the complaint that this was based on mail or wire fraud. So, in order for you to suggest this, there's a heightened standard under this Rule 9b that was not met. And so that, and then it even goes into the next element, right? Fails to allege a continuous pattern activity. Okay. So let's get down to the end of this, because I mean this is relatively straightforward at this point. What I'll do, I can continue a deeper dive, breaking this down brick by brick on a page, but I wanted you to be able to walk away with some understanding on some of the accusations and how to defend yourself against the accusations, right? Of course, you're gonna put forth a motion to dismiss. And in that motion to dismiss, you're going to be breaking down each of these alleged actions and, you know, show that that certain things weren't proven, or there was a heightened standard legal that was legally required that wasn't proven. I mean, even right here, taking a look at it, plaintiff's California premises liability claim against UMG Recordings and Motown Records should be dismissed. Under California law, premises liability is a form of negligence. To state a viable claim, you put the rule, right? And then you say, okay, now after you establish the rule and you explain what that is, you say plaintiff's claim is based on a false parent company assertion that in such capacity, blase, 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 their created agency, right? And with agency comes knowledge, consent, direction, approval, and ratification of certain acts. All three of these conclusory allegations are false. Motown was not Love Records' parent company. Neither UMG Recordings nor Motown provided or paid for whatever security was in place at the time of the shooting. The legal assertions about the supposed relationship between UMG Recordings, Motown, Love Records have no factual basis whatsoever. Plaintiff's eighth cause of action as against UMG Recordings and Motown Records, which is also jettisoned in the unauthorized SAC, should be dismissed. For the foregoing reasons, the UMG defendants respectfully request that all claims then be dismissed and that the court award them such other further relief as deemed just and proper. So here we go. So again, these are the attorneys for the UMG defendants. I personally think that this was a great legal response, and I'm interested in seeing how the other party has responded. But as of right now, I mean, listen, it's nasty work out here. It's the nature of warfare. Let's go. Okay. So now let's move to this next phase. Okay, let's go right here. What should we do? Let's go right here. All right, so this is listen, man. Shout out to Pride Cashman LLP. All right. So in this situation, you know, there's a document submitted to the judge, and you can tell that this is recent, right? You see March 28th, 2024. And what so you already saw the motion to dismiss, right? And so what I want to do right here, I want you to really unpack this. This is only like 3 pages or so, but this summarizes the memorandum of law and the notice for the motion to dismiss that was presented and filed in this court. And so now, there's this, letter to the judge, because again, these are people that, of course, they're, judges, they're going to read and they're going to review. But if you could summarize these things to the best of your ability to give the judge a high level synopsis so that, it can better aid them in making a decision. This is where the effective communication in the form of writing becomes very apparent. So here we are. So, dear judge, we are counsel to defendants UMG Recordings Incorporated, and look how they take the shot again. Erroneously sued as Universal Music Group. Yeah, you listen, man. When people are doing business, sometimes they have DBAs or trademarks where they may have an alleged name, but you always want to get to whatever the actual entity is, right? Get to the actual entity. Then you have Motown Records and Sir Lucian Grain. Collectively, the UMG defendants in this action, we respectfully write in response to the March 27, 2024 letter from plaintiff's counsel, Tyrone Blackburn, right? So Tyrone had a letter, and let's do this. What I'm going to do. So what we're going to do, we're going to unpack both letters, right? All right. So we'll do that. Okay. So Mr. Blackburn complains. Listen, man, it's the word choice. Complains of sua sponte, waiver of service of process, and filing of a Rule 12 B6 against them asserted amended complaint dated March 2nd, 2024. Having filed a complaint making baseless accusations, again, the shots being taken, of criminal behavior against the UMG defendants on February 26, 2024, notice that they didn't mention Mr. Combs. They made sure that they did not mention Mr. Combs. And so, again, the tactic is to distance yourself from Mr. Combs, let him figure that out. While at the same time, Universal Music Group, Motown Records, and Sir Lucian Grange are going to do what they need to do. So let's keep going. So Mr. Blackburn made no effort to serve process. It appears that Mr. Blackburn believes that unjustly accused defendants should be powerless to respond to such a pleading. The UMG defendants were absolutely entitled to waive service of process under Federal Rules of Civil Procedure 4D, instead of allowing Mr. Blackburn to endlessly file unauthorized pleadings. In his unilateral game of pleading whack-a-mole, taking more shots, perhaps he believes that he can make outrageously false allegations in a pleading, never serve them, let them marinate in the press for a month, and then completely abandon them, file equally false and legally baseless claims based on completely different accusations, and there is no harm, no foul. There is harm and there is foul, and that is what the UMG defendants motion addresses. What are they saying? You filed the complaint that you never intended to serve. You made sure that the media, that the culture, as they call it, had all of these salacious allegations against my client. And yet you never gave me the proper due process to defend my clients to the best of my ability. And then when you make these claims, they're so baseless, they're so egregious, and you erroneously sued me in the wrong name. Sheesh. Let's keep going. Effectively admitting that the FAC he authored, signed, and filed against the UMG defendants is foundationally based on completely fabricated allegations, which we pointed out to him by letter dated March 4th, 2024. Mr. Blackburn protests that he filed a purported second amended complaint that he suggests cures his and plaintiff's prior frivolous pleading. So, and we're going to take a look at this. So what they're saying right here is that in that other complaint that you had, you admitted in your letter that you presented some false accusations. So why should we take you seriously now? And then now you're suggesting that you cured it, and we still should dismiss it. Right? Let's keep going. And they're going to say Mr. Blackburn is wrong for multiple reasons. And because now they get into his character and they get into bad faith, they get into sanctions, and let's go from here. First, Mr. Blackburn mischaracterizes our March 4th letter as the UMG defendants Rule 11C2 motion, which supposedly triggered his and plaintiff's 21-day clock to cure their frivolous conduct. That is incorrect. We expressly stated in our March 4th letter, this letter is being sent to you in advance. Oh, what again? Oh, I see how they setting them up right here. Man, I love this. This is exciting. So in advance of our making a Rule 11 motion in accordance with the requirements of Rule 11C, such motion, if we are required to make it, will provide you with the required 21-day notice before we seek the imposition of monetary sanctions against you and your client for having filed a complaint and now an amended complaint, both of which are in patent and egregious violation of the requirements of 11A and B. So what they're saying is that for you to suggest that we are moving forward with sanctions and that we didn't follow our process accordingly means that you didn't even actually look and assess what we actually said, because we said that we would let you know when we were moving forward with a Rule 11 motion. We would give you your required 21-day notice in advance. That's why they said in advance. So basically, you're not reading here. You're not reading. And if you are reading, you're not actually comprehending. So again, this is another attack on this attorney's credibility, another attack on the veracity of the claims that he has alleged, another attack, and on if this suit will even stand. So let's keep going. Second, Mr. Blackburn mischaracterizes our Rule 11 based demand as seeking only the withdrawal of certain false and frivolous allegations without withdrawing all allegations and claims against the UMG defendants. That too is incorrect. We expressly stated in our March 4th letter, you can avoid a Rule 11 motion only by withdrawing the complaint or immediately amending it to remove all allegations and claims against our clients. That has not been done. We will serve and file our Rule 11 motion in due course. I gave you a warning, little homie. I gave you a warning, little homie, and you didn't respect the code. So now I got to put the fire to you. That's what they just said. I gave you a warning. I let you shine. I let you get your talk. I let you get it off. And now, let's get it. In his unauthorized SAC, Mr. Blackburn has jettisoned every one of the FAC's foundational allegations against the UMG defendants. The FAC included the completely unfounded allegation that the plaintiff supposedly personally saw Sir Lucian Grange attend Combs' alleged sex trafficking parties and also saw Ethiopia have to marry him there. Motown Records is supposedly liable under a doctrine of respondeat superior as the parent company of the co-defendant, which is Combs' record label, and UMG Recordings and Motown Records supposedly funded Combs' alleged sex trafficking parties with bags of cash. In quotations. Every one of these foundational allegations for the claims against the UMG defendants have been wiped from the SAC, but while busy accusing the UMG defendants of bad faith and filing their motion to dismiss, which would seem to be a textbook example for the psychological diagnosis of projection, nowhere does he offer any explanation for the provenance of these allegations to begin with. Indeed, his feeble, calling him weak. Sheesh. Indeed, his feeble attempt to justify his new general partnership allegation, an allegation directly refuted by both Miss Habtemariam and her counsel, and conclusively contradicted by paragraph 16.11 of the license agreement attached as Exhibit A to the declaration of Miss Braithwaite filed in support of the UMG defendant's motion to dismiss, itself confirms that the parent company allegation was completely made up by Mr. Blackburn. Now, notice, they're not even referring to the plaintiff anymore. They are referring directly to Mr. Blackburn. They are referring to the counsel. They are alleging in a very surreptitious way that you, as counsel, are sincerely, genuinely, and intentionally attempting to deceive the court with these salacious claims. Now, is this true? We'll get to it. But I want you to notice how they targeted Mr. Blackburn. See, they're setting up the pretext to justify the sanctions. Okay? Now, lastly, we wrapping up. So further, since Sir Lucian Grange has never been to any of Mr. Combs' homes, the plaintiff's assertion in the first amended complaint that he personally saw Mr. Grange disappear with Mr. Combs into a room for hours can only be either a delusion or a lie, since the exact same allegation is made in the first amended complaint as to Miss Habtemariam, who was also never at any of Mr. Combs' homes after plaintiff was supposedly hired by Mr. Combs. It seems fairly clear that it was no delusion, but it is a lie. That means that it was no mistake. You are indeed a liar. Mr. Blackburn has simply swapped out the original baseless foundation for the RICO and sex trafficking claims against the UMG defendants for a new baseless foundation invoking only loosely worded press reports about Motown Records partnering with Combs, then newly formed Love Records to distribute a single album. The unauthorized SAC invents a non-existent general business partnership between Motown and Love Records as the new linchpin for plaintiff's liability theories. As Mr. Habtemariam's declaration in support of the UMG defendant's motion shows, Mr. Blackburn's assertion that she supports his allegation is untrue. Third, Mr. Blackburn pretends that he was somehow authorized to file the SAC to address our demands, and the UMG defendants are barred from filing any Rule 11 motions as to the FAC. Mr. Blackburn failed either to obtain the UMG's defendants' written or any consent, or leave of the court prior to his filing in violation of Rule 15A2. The UMG defendants properly moved against the FAC, and as I indicated above, we will shortly be serving our Rule 11 motion on Mr. Blackburn, and assuming he does not drop all claims against our clients, we'll be filing it with the court in accordance with Rule 11. We regret burdening the court further, but we believe that the court is entitled to the facts. Man. Oh, man. Did y'all hear that? Because maybe you didn't read it, but if you listening, you driving, you got your headphones in, you at the gym, you just sitting back, laying down. When I'm telling you, man, wow. Essentially, man, is calling this man a liar. Said that at this point, Judge, this is not even delusion. This is just a lie. At first, I thought it might be a mental thing for him. Maybe he's a little crazy, alleged. Maybe he doesn't know what the harm that he's caused. But there is no such thing as no harm, no foul, because there has been harm and there has been foul. So, man, this is getting ugly. This is getting ugly. Okay. Sheesh. Okay, man, let's man. I want to get to, I know we need to go ahead and take a look at what Attorney Blackburn said. I think that in all fairness, right now, I'm seeing people a little swayed. In all fairness, let's make sure that we give him his proper opportunity to respond as well. Let's go right here. All right, so we're back. And at this point, everybody should be brought up to speed. You should understand who the parties are in this case, what's happened since the filing of the first amended complaint, because it started with the complaint, then the complaint got amended. The allegations that have been brought forth in the form of a defense where they are alleging that the plaintiff, and specifically the plaintiff's counsel, are not only bringing forward baseless claims, that these claims have no foundation, whether legal or otherwise, that they are completely conjecture, and the defense attorneys are literally arguing that these claims are not even delusion, they're just flat out lies. And on that basis alone, if these claims are not dismissed, specifically as it relates to the parties that I represent, not only am I bringing sanctions, it's more hell to come. Man, this is, so we understand that frame of reference. We understand that was put forth, in a motion to dismiss and a memorandum of law to support that. And in a letter, that was presented and filed with the court. And so now I want us to look at what Attorney Blackburn has put together. All right. Dear Judge, as you know, this firm represents the plaintiff, Rodney Jones, announcing who you are. This letter addresses the notice from the clerk of the court regarding the second amended complaint and the letter filed by the defendants dated March 28th, 2024. And so just even looking at the date, you wasted no time. I responded to you on the same day. So how dare you even make a suggestion that I'm not one of the best? You see how timely I am? Because notice that the defendant's counsel was interweaving underhandedly this argument about timing and a lack of professionalism and a lack of being correctly identified. And here he goes and he responds on the same day. So, I like the motion of this. Let's keep going. Pursuant to the 21 days safe harbor rule, the plaintiff has 21 days To withdraw or amend the allegedly deficient pleading, plaintiff amended the allegedly deficient pleading on March 25th, 2024, on the 21st day of the 21-day safe harbor window. Cutting it close, but you got it done. On March 26, 2024, the clerk issued a refiling notice due to an error in the second amended pleadings heading. And a lot of times, look, when you're filing in different courts, especially in California, New York, there are certain requirements that have to be met in order to satisfy that particular court, depending on what it is. And so a lot of those things are stylistic, so that's something to keep in mind. It's not the end of the world, but I mean, it happens. It happens. On March 27, 2024, plaintiff corrected the document and refiled it. The clerk has issued a notice stating that the court needs to provide leave to amend. Okay. Let's keep going. Plaintiff respectfully requests leave to amend as the amendment is being made pursuant to the 21 safe harbor rule of what the plaintiff has viewed as a demand to amend or withdraw. So right now they're asking for some time. Okay. Asking for some time. Defendants have indicated that they have no intentions of giving plaintiff consent to amend the pleading, even though they sent the threat of sanctions letter demanding that the complaint be withdrawn or amended. As plaintiff sees no reason to withdraw the complaint against defendants UMG, Motown, or Lucian Grange, plaintiff has opted to amend the pleading. It is clear from the second amended pleading that the defendant is either negligently or intentionally funded the activities of defendant Sean Combs before filing his pleading. Plaintiff only had the word of Mr. Combs, the evidence in his possession, and his personal experience. See, we talked about this earlier. We talked about this earlier. We talked about this earlier because I told you that a lot of times when the counsel is putting forth these complaints, you only have certain evidence at your disposal. You may not have 5 to 10,000 to go get this private investigator and confirm A, B, C, D, and E. So you're going off the information that is being presented to you. You're going off, the questioning, your intake form and your own examination and questioning of your own client and any other surrounding witnesses potentially. But especially when you're putting up this money yourself, you're going to be doing the best that you can. Now, is this necessarily true? Who knows? But just to understand the context of just people being human and people having ulterior motives. And sometimes, in good faith, you can just be relying on what your client said and then come to find out that your client was actually, could be lying to you. So that is a thing too. So let's see how this plays out. So he says that the plaintiff only had word of Mr. Combs, the evidence in his possession, and his personal experience living with Mr. Combs from September 2022 to November 2023. I think that is very odd to be living with another man. It's not your actual relative. Be living in his home for over a year. And you have your own family, your own legacy, your own responsibility. So let me put a pause right there before we go forward. For men that are listening, you need to have your own at all times. There's the scripture is very clear about, having your own. And so when you become dependent on another man, you put yourself at their mercy. That's an immediately vulnerable position. And when you're vulnerable and there's predator and there's prey, as Alton Maddox put it, the late, the great, you're liable to be exploited and taken advantage of. This is the nature of business. This is the nature of predators. So for him to be in that type of environment for that extended period of time, to a person that you have all of this remorse, at some point it goes from a mistake to a decision, and we have to make better decisions. All right. So let's keep going. Miss Haptamarian's declaration provided plaintiff with the confirmation he needed concerning the business partnership and the funding of the Love album that Mr. Combs had shared with the plaintiff directly. So remember, going back to a lot of the arguments that were being presented by the defendant's counsel. That a large part of the argument was at the fact that this wasn't an actual partnership. This was a licensing arrangement. And so now that claim is being disputed, that the basis of this being a business partnership and the basis of there being some level of funding for the Love album is indeed true. It gets deeper. It is also clear that many of the claims raised by plaintiff in his second amended pleading are accurate. As the events of March 25th, 2024 have revealed, Mr. Combs' drug mule, Brandon Paul, was arrested in Miami, Florida for cocaine possession, and cocaine was in his carry-on luggage, as plaintiff stated in his amended pleading. Mr. Combs is being investigated for possible sex trafficking, as plaintiff has alleged and thoroughly detailed with exhibits and examples in his pleading. The raid produced guns in both locations, as plaintiff detailed in his pleadings. So what is he doing right now? He's letting you know that everything that he said, everything that he alleged has come to pass. That there's truth, that there's veracity, that there's some type of accuracy in the statements that are being presented. And that that shred of evidence is enough to move forward in this case, especially with all parties that are involved. Because again, when we go back to what we were looking at the very beginning, this is related to racketeering and corrupt organizations. This is related to influences of negative parties. So let's keep going. So the defense counsel was framing everything as if the plaintiff was based on a lie, was based on delusion, was based on a falsity. Whereas plaintiff and plaintiff's counsel saying, no, there's some things that had to be changed. There were some things that had to be corrected, but that's the nature of law. That's the nature of litigation. And in fact, the very things that I have alleged have indeed come true. The guns, the drugs, the raids. So that there's this push and pull that's happening here. And now that creates that gray area for things to be figured out. Here we go. If the court requires a formal motion or a letter motion so plaintiff can lay out how the amendment against the moving defendant would not be futile nor filed in bad faith, we will gladly do so. The defendants were Sean Combs' general business partner, as that term is defined by the courts in the state of New York. A partnership is an association. Now here comes the shade. So you telling me it's not a partnership? That's what he's saying. So you telling me it's not a partnership? Well, let me provide the definition for you and put it in a big bold font, just so you know what's going on. Let me cite it for you. A partnership is an association of two or more persons to carry on as co-owners of a business for profit. When there is no written partnership agreement between the parties, the court must determine whether a partnership existed from the conduct, intention, and relationship between the parties. No one characteristic of a business relationship is determinative in finding the existence of a partnership in fact. Factors to be considered by the court conclude the sharing of profits and losses, the ownership of partnership assets, joint management and control, joint liability to creditors, the intention of the parties, compensation, the contribution of capital, and loans to said organization. Here, after giving you the rule, here, the defendants are desperately trying to rewrite history to distance themselves. Didn't I just say this earlier? Are trying to rewrite history to distance themselves from Mr. Combs. By their own admission, they funded the creation of the Love album and partnered with him to establish Love Records. These are their words, not the plaintiffs. Man, I said this is part of the tactic. Remove me off of that because I don't want to be liable for any of it. Aside from their public statements, their actions indicate a general business partnership under New York state law. Profit sharing is one of the two most important factors. So what he's doing right now is now he's dissecting their argument and saying, okay, well, you said that this wasn't a general partnership that I defined as wrong and that this was a licensing agreement, when the actual basis for how this agreement, this arrangement between Mr. Combs and these other parties that I mentioned in my amended complaint is that the way that this came about was focused on profit sharing. So we're looking at this from a factor test, and this factor is considered one of the two most important. So let's see if he's going to talk about the other most important factor. So it goes on to say, Profit sharing is one of the two most important factors in determining the existence of partnership, along with control over the business. To determine whether the parties expressed an intent to be in a partnership, the court may look at their writings and conduct and look at what's italicized. Evidence of expressions of intent could conclude the parties' statements that they are partners, a signed partnership agreement, or one party holding the other out as a partner. This inquiry is separate and apart from other factors and should only include evidence not specifically probative of the other factors. As detailed in the letter dated March 27, 2024, plaintiff determined that the UMG and Motown Records had a general business partnership based on his conversations with Mr. Combs and the public statements made by the defendants on their website and on their LinkedIn business pages. In the relevant part, the defendant's website states the following: Diddy and Motown partner up. Wow. Listen, let me tell you. So he said, y'all thought y'all had me. I'm going to one up you. I'm going to go to your site. I'm going to go to your site. And he says, based on the conversations with Mr. Combs and the public statements made by defendants on their websites and on their LinkedIn business pages, the defendants' websites state the following: Diddy and Motown partner up. Diddy will be dropping his latest album on our label later this summer. On top of that, we are helping establish his latest and most exciting venture yet, Love Records. On their LinkedIn, which the court can access from the following link, defendant UMG states the following: Love Records, hand agreement, Motown Records. Diddy's new album will be the first release from Love Records in partnership with Motown. Man, listen, man. Man, these quotes are not one-offs. In the interest of time, plaintiff has decided not to inundate the court with all the newspaper and magazine coverage that this partnership received. The plaintiff's amended complaint outlines the defendant's liability as a business partner. The defendants cannot have it both ways. You cannot profit off Mr. Combs at the expense of victims like my plaintiff. But when the federal investigators kick down his door, they try to cut and run and pretend that they only had limited involvement with Mr. Combs. Get over here. Get over here. Man, let's go, man. They heating up. This is heating up right now, right? The defendant's pearl clutch. Wow. Oh, he called him feminine. Oh, he was ready. The defendant's pearl clutch is breathtaking. The defendants knew for years that Mr. Combs had a propensity for violence. As detailed in the amended complaint, Mr. Combs assaulted their former executive, Steve Stout. According to former UMG executive Steve Stout, Combs and two men barged into his New York City office and attacked him with a champagne bottle. Combs was charged with second-degree assault and criminal mischief. UMG knew this and did not end their business partnership with him. In fact, they turned a blind eye and continued their business partnership for several years after the attack. If not for Cassie Ventura's November 16, 2023 lawsuit, UMG's history of running to Mr. Combs for partnership opportunities would have continued. Don't go nowhere now. You knew what I was doing all along. You know, there's this saying, something along the lines of, when you lay down in dirt, when you lay down with fleas, when you lay down with pigs, along the lines of that. Essentially, you dug your grave, now you gotta lay in. Don't try to jump out now when the fire get hot. Don't try to jump out now. All right, man. This is getting good. This is better than TV. The plaintiff was clear when he said he witnessed Mr. Grange and Miss Habtemariam at Mr. Combs' home and parties associated with the Love album. Of course, plaintiff did not meet them and speak with them. That was not his statement. He said Mr. Combs identified them and used them to impress and entice plaintiff to engage in activities that the plaintiff did not want to do. This was one of the many tools plaintiff identified as grooming mechanisms implemented by Mr. Combs. Oh man, they saying this man was grooming. You know, you ever did that before? You know, you somewhere and you feeling like you the man, and you like, oh yeah, man, that's that's coach such and such, and oh yeah, man, that's the bodyguard, and oh yeah, man, that's my partner over there. You know, you making yourself look bigger than what you are because you are communicating to the person that I am in a position to put you on. And because I can put you on, you can reap the rewards and you can reap the benefits of who I am and what I am, so long as you do these particular things. Let's keep going. Once defendant sent plaintiff a letter denying ever being present at Mr. Combs' residence or parties associated with the Love album, plaintiff took them at their word and amended the pleading as he was required. As plaintiff stated throughout his pleadings, Mr. Combs drugged him through laced alcohol at these parties. Plaintiff has woken up next to several women not remembering what happened the night before. If Mr. Combs lied to plaintiff concerning the identity of the attendees at his parties and the plaintiff later learned from those alleged attendees that they were misidentified, then the plaintiff has an obligation to correct the record, which is what he did. This does not remove UMG, Motown, or Lucian Granger's liability concerning their unchecked funding of the Love album and Love records. It does not matter what document they produce evidencing the terms of their relationship with Mr. Combs. It is important to thoroughly assess what is written versus what was done. Plaintiff strongly believes that the court will soon learn the defendants are engaging in a game of smoke and mirrors. We respectfully request leave to amend so plaintiff can file his second amended complaint, which will include some of the issues they wanted to be cured, as well as the addition of Cuba Gooding Jr. as a defendant. We thank the court for his time and attention to this matter. Respectfully submitted. Sheesh. So, personally, I think that this was a decent response, right, to the motion to dismiss, because that they're attacking your credibility. They're suggesting that you're making everything up, while at the same time, you're able to show that this actually was a partnership. And this was a partnership by admission of your own words. In fact, I'm going to pull it from your LinkedIn. No, I'll do you one further. I'll pull it from your magazines. I'll pull it from your articles. Let me actually go to your website and pull that same information. And then let me see if you keep that same information. Then taking a step further, my client did correctly identify to the extent that he was able to do so. But then I noticed that, that this paragraph, him trying to justify why he cured his initial complaint and removing those names, because he's saying that his client was actually drugged and would wake up next to multiple women and not know what's going on. And you got to be careful there, because what else did he misconstrue? What else is he unsure about? What else did he think that he saw that he actually didn't see? So you want to be very careful about that, because the characterization of that suggests that your own client may not be the most viable party to really provide this information. However, outside of their own personal testimony, the fact that you do have videos, the fact that you do have recordings, the fact that you do have text messages, the fact that you got emails, like those things help aid that, because now it's not just relying on you, and apparently you were in a drunken state a lot of the time. And so then now one has to also look at the nature of that and to suggest, were you being forced to take these drugs? Were you were these things by voluntary, selection? And this goes back to the nature of what men should understand and take away from this is, at what point do you have some level of culpability and responsibility in your own decisions and the only admission of your own faults? And again, it is true that the deck can be stacked against you, but it is also true that you do make decisions.